Imagine waking up to find your children gone, your name stripped from official records, and no criminal charge ever filed against you. There's a place where this happens every single day, behind closed doors, with no cameras allowed and no public record. What kind of court operates in complete darkness, and why can't you know what happens inside? Family courts exist in nearly every country on Earth, designed to handle divorce, custody battles, and child protection cases away from the public eye. These courts were built with good intentions, to protect children's privacy and allow families to resolve painful disputes without media scrutiny. But that same secrecy creates a system where life-changing decisions happen without oversight, without transparency, and sometimes without the basic protections we expect from justice. In the United States alone, family courts process over 1 million custody cases every year. In the United Kingdom, approximately 55,000 children enter care proceedings annually. Behind every one of those numbers is a human story, and unlike criminal trials where evidence must meet high standards and proceedings are public, family court operates under different rules entirely. The modern family court system emerged in the early 1900s, born from the progressive era belief that children needed special legal protection. Courts began closing their doors to the public in the 1920s and 1930s, arguing that children's identities and family matters deserved confidentiality. By the 1960s, every U.S. state had established some form of closed family court system. The shift intensified in the 1980s and 1990s as child protection cases surged nationwide. Federal laws created financial incentives for states to remove children from homes, with states receiving payments for each child placed in foster care. What started as protection evolved into a system processing cases at industrial scale. By the 2000s, critics began documenting systemic problems. Reports emerged of parents losing custody based on disputed evidence, of court-appointed evaluators with no oversight, and of judges making permanent decisions in minutes. Investigative journalists found that in some jurisdictions, parents had less time to present their case than someone contesting a traffic ticket. The system operates through a simple but powerful mechanism. A complaint is filed, often by a social worker, sometimes by an ex-spouse, occasionally by a concerned neighbor. An emergency hearing happens within days, sometimes hours. Evidence rules are relaxed. Hearsay, the kind of testimony that would never survive in criminal court, becomes admissible. Decisions made in those first 72 hours can determine the next months or years of a family's life. Court records, when they can be accessed through Freedom of Information requests, paint a consistent picture across jurisdictions. In 2023, the Marshall Project obtained sealed records from 12 states showing that in approximately 60% of emergency removal hearings, parents had no attorney present at the initial hearing. The same investigation found that hearings averaged 15 minutes in length, with some lasting under 5 minutes. Academic research confirms the pattern. A 2022 study published in Family Court Review analyzed 12,000 custody decisions and found significant disparities based on factors unrelated to child safety, including the income level of the family and whether parents could afford private attorneys. Families with legal representation maintained custody in 78% of cases, while those without representation lost custody in 71% of cases. Court-appointed evaluators wield enormous power in these proceedings. These are psychologists or social workers who assess families and make recommendations to judges. Yet oversight remains minimal. A 2021 investigation by the imprint found that 19 states have no mandatory training requirements for custody evaluators, and 23 states have no formal complaint process. The same investigation identified evaluators who continued practicing after multiple complaints of bias, falsified credentials, or outdated methods. The financial incentives complicate everything. Under Title IVE of the Social Security Act, states receive federal reimbursement for foster care costs, but not for family preservation services. States can bill the federal government roughly $150 per day for each child in foster care, but receive minimal support for programs that keep families together. Former caseworkers have testified that supervisors tracked removal numbers and that promotions sometimes correlated with high removal rates. Child welfare advocates argue the system saves lives. They point to cases where intervention prevented serious harm, where children were removed from genuinely dangerous situations, and where confidentiality protected vulnerable kids from stigma. They note that opening courts to public scrutiny could expose children to media attention and trauma. Many social workers and judges work in impossible conditions, managing caseloads double or triple recommended levels, making life or death decisions with incomplete information. Critics counter that secrecy enables abuse of the system itself. Organizations like the National Coalition for Child Protection Reform argue that most removals involve poverty, not abuse, and that family preservation should be the default. They cite studies showing children generally fare worse in foster care than with their biological families, even in troubled homes, except in cases of severe abuse. The debate hinges on competing values: child safety versus family integrity, swift action versus due process. Data remains frustratingly incomplete because the system documents itself poorly. The federal government doesn't maintain a comprehensive database of family court decisions. No national standard exists for what constitutes abuse or neglect, with definitions varying dramatically between states. Some classify educational neglect, a child missing too many school days, as grounds for removal. Others require evidence of physical harm. This means identical family situations can result in opposite outcomes depending on the county where you live. Sarah Morrison lost custody of her 2 daughters in 2019 after her ex-husband alleged she had a drinking problem. According to court transcripts obtained through her attorney, no toxicology evidence was presented, no witnesses testified to seeing her intoxicated, and no police reports documented any incidents. The judge awarded emergency custody to the father at a 12-minute hearing. Morrison didn't see her children for 9 months. By the time a full hearing occurred and custody was returned to her, her younger daughter had developed anxiety disorder, allegedly struggling to trust that any living situation was permanent. Stories like this appear in every state, across every demographic. Marcus Chen, a software engineer in California, spent $87,000 in legal fees over 2 years fighting allegations made by a court-appointed evaluator who later admitted in a deposition to misremembering which family she had interviewed. He was restricted to supervised visits with his son for 14 months based on that report. By the time the error was corrected, his relationship with his son, then 7 years old, had fundamentally changed. The system affects children caught in the machinery regardless of the outcome. Therapists who work with families describe children who learn not to speak freely, who understand at age 8 or 9 that their words might be used in court, who stop trusting that adults can protect them because they've watched their parents rendered powerless. Even when reunification happens, the experience leaves marks that therapy can address but never fully erase. Think of most court systems as operating in daylight. Criminal courts have public galleries, transcripts, appeals processes, and constitutional protections built over centuries. Family court operates more like a private arbitration, but with the power of the state behind it. Legal scholars point to a fundamental tension. The same confidentiality that protects children's privacy also prevents accountability. Professor Claire Huntington of Fordham Law School argues that family courts have become administrative systems processing cases like an assembly line, rather than judicial bodies carefully weighing evidence. When courts seal records, journalists can't investigate. When hearings happen in closed rooms, the public can't observe whether justice is being delivered evenly. The broader pattern reveals how institutions designed with good intentions can drift toward dysfunction without correction mechanisms. Family courts began as child protection, but the combination of closed proceedings, relaxed evidence standards, financial incentives, and overwhelming caseloads created conditions where errors compound and abuses hide. This matters beyond individual families because it demonstrates how any system operating in darkness, even one built for noble purposes, will eventually demand sunlight. We know family courts process over 1 million custody decisions annually in sealed proceedings with relaxed evidence rules and minimal oversight. We know the system can separate families in minutes based on disputed allegations, and we know children and parents often wait months or years for full hearings. What we don't know is how often the system works correctly versus how often it fails, because the data doesn't exist and the records stay sealed. We also don't know whether reform is possible without sacrificing the privacy protections these courts were built to provide. The question facing lawmakers and advocates now is whether transparency and justice can coexist. Several states are considering bills to mandate attorney representation in all custody cases, limit the admissibility of hearsay evidence, and create independent oversight boards for custody evaluators. Colorado passed limited reforms in 2023 requiring recorded hearings in all removal cases. If these pilots succeed, other states may follow within 3 to 5 years. Some jurisdictions are experimenting with redacted transcripts made available to researchers and journalists while protecting children's identities. Early results from Massachusetts show this is technically feasible but faces resistance from judges concerned about criticism. Widespread adoption faces significant political and institutional barriers. Congress could tie federal foster care funding to due process standards, requiring states to meet baseline protections for parents in exchange for Title IV money. Legislative proposals exist but have stalled repeatedly due to disagreements over states' rights and child welfare funding. Major reform would require unusual bipartisan cooperation. Without sustained public pressure or high-profile cases forcing change, most family courts will likely continue operating as they have for decades. The system's defenders are numerous and well-funded, including state agencies dependent on federal dollars and professionals whose careers exist within current structures. Incremental change is more probable than revolutionary reform. The family court system represents one of the last places in American law where you can lose fundamental rights, your children, your reputation, without the protections guaranteed in every other court. Reform isn't about dismantling child protection. It's about ensuring protection applies to everyone in the room, including the parents fighting to stay parents. If you found this investigation valuable, watch our next video examining what happens inside juvenile detention centers, another system operating largely outside public view. Understanding these hidden institutions is the first step toward changing them.